So is what we're seeing now different than what we've seen in previous years?
Yes.
We're on the offensive for
Yes.
once in my lifetime.
Yeah. I mean, I've never seen anything like
Yeah.
this. I'm Duane Urban, and welcome to the Urban Defense Podcast, featuring discussion on firearms, concealed carry, self-defense, the law, and much more. Designed to inform, educate, increase your survival in a critical incident. Welcome to the Urban Defense Podcast. I'm Duane Urban. Along with me is Andrew Saller, managing partner of Saller, Lord, Ernstberger, and Inslee. And in today's episode, we're going to be talking about national Second Amendment cases that could impact you and potentially set the legal landscape for the rest of the country. Back with us again is our returning guest, Andre McDonald from the McDonald Law Firm. Andre, thanks for being back.
Thanks for having me back, Duane.
Absolutely. And before we get started, though, there's a few Maryland things that we wanted to talk about. Andrew, you have a couple things you wanted to bring up.
Yes, Duane. The Maryland General Assembly is in session, as we all know right now, and they will be sitting until April 8th. And during this time, they are considering a wide variety of bills that really are going to impact pretty much all of us here in Maryland. First and foremost, House Bill 430, the firearms liability insurance, that if you are concealed carrying in the state of Maryland, you would have to have a $300,000 liability insurance policy. Violations of this statute could carry up to 5 years in prison.
Really?
Very common for fundamental rights. You have to have liability insurance to exercise them.
Very progressive.
Very. Now, with this, what's most interesting about it is that if up until any point that you are convicted, if you obtain the liability insurance, they are to dismiss the case.
Yeah, I did read that. So you could get charged with it and go and get the insurance and then say, ta-da,
Yes.
and then you're fine.
Yes. At any point before the trial concludes, if you get the insurance, ta-da.
But let's talk reality. What is the likelihood that an insurance company, if you're filling out an application for this insurance, if this ever passed into law, they're likely going to ask you in that application, do you have any pending litigation?
I certainly would. And every insurance application I've ever filled out asked me that.
So the likelihood of you getting the insurance is
Meaning after the fact,
After the fact.
So, I mean, but they're going to have to find insurance companies that are going to offer this type of insurance.
And I really question, what are the premiums going to be?
I can only imagine.
So everyone pay attention to House Bill 430, and let's watch and see how it goes. It's been referred to committee, and we'll have more for you at a later date. Coming along the same lines, we've got House Bill 346. It's going to amend the ability to possess and distribute marijuana and not be a felony charge of distribution with possession of a firearm, which would carry a 5-year mandatory minimum usually.
So what you're saying is if they're distributing marijuana and they have a firearm with them, it's not going to be a felony? Is that where you're going with this?
If a person is at least 21 years old, they can manufacture for personal use cannabis products or concentrated cannabis for personal use or adult sharing at a private residence if the manufacturing process does not involve the use of a volatile solvent. And a volatile solvent, you may say.
I was going to say, have they defined what a volatile solvent is?
A solvent that is or produces a flammable gas or vapor that, when present in the air in sufficient quantities, will create explosive or ignitable mixtures, includes butane, hexane, and propane.
But not Mr. Clean.
Not Mr. Clean. So
like meth lab type stuff, I would assume.
Correct.
So this is mostly a person carrying a firearm while doing those types of activities. It doesn't really relate necessarily to wear and carry permit holders.
Correct.
Okay.
I would be advising one to avoid the situation generally, but that is what it is.
Got it.
Then also we have House Bill 421, the use of possession of a machine gun in the commission or attempted commission of a felony. Your thoughts, Duane, of using a machine gun to commit a felony?
Well, given the current cost of transferable NFA firearms, I would think that most people aren't going to do that, but converted guns, I guess.
So this would change it to currently a person may not use or possess a machine gun in the commission or attempted commission of a crime of violence. This would change it to be a felony or a crime of violence.
I mean, really, any machine gun. So we could be talking about guns that were unlawfully converted. We could be talking about guns with switches on them, things like that.
Correct. So if you and I went around and decided to steal 1,001, paper clips, and we happen to have machine guns with us at the time, now we're facing a separate charge and a separate conviction of up to 20 years of imprisonment.
Got it.
When I see Delegate Attar, I will ask her how many times this has been a problem and what's going on with this, that we need this.
Yeah.
Likelihood of passage?
Slim. Just her on as a sponsor of it. So we'll see. Might be in search of a problem. Or there might be a wave of machine gun violence that I'm unaware of in our state. Then we've also got, this has a slim chance of passage, but it should be monitored still. House Bill 439, first-degree assault with a firearm. In Maryland, if I point a handgun at you, that's a first-degree assault, absent justification. This would insert the word a person may not intentionally commit an assault with a firearm. So it would require, to get all lawyerly, mens rea, that you intend to commit the first-degree assault by pointing.
In my mind, that's kind of interest to me because let's say you have someone that's a concealed carry holder, and we talk about in classes when you should and when you shouldn't draw the weapon, and we discuss the pointing of a firearm, but maybe the situation where someone pulls out their firearm and points it maybe before deadly force is actually warranted at that point, and their defense could be, well, I was in fear. Now, whether that fear was reasonable or not given the circumstances to raise that level to deadly force, now the fact that they're saying that wasn't their intent, their intent was to protect themselves, well, then potentially then that would be helpful to them.
Absolutely.
So that may not be a bad, it might be something that would work out in our favor.
Absolutely. Like I said, I think it's a very slim chance of passage, but I agree with you, Duane, that it would change the playing field entirely when it comes to assault by pointing.
Who is the sponsor of that, just out of curiosity, if you have it there?
Delegate Taylor, Kim Taylor from Prince George's County.
Democrat?
Yes.
Okay.
And it's just her as the sponsor.
Okay.
And then I don't know if any of my friends who are into gaming know, but in Maryland we have the voluntary exclusion program for the casino gaming, where you can fill out an application where you will then be excluded from all casinos in the state of Maryland if you just can't help yourself due to your gaming addiction. And if you do then go to the casino, you can be charged with trespassing, and I've represented people that this has happened to. Well, there's a proposal here, House Bill 794, 3 sponsors to make the same thing happen with firearms here in Maryland, where the Maryland Department of Health will create a registry, and you can voluntarily be listed on it, and it would then be a crime for anyone to sell you a firearm.
Does the legislation provide for you to be removed? You're to voluntarily remove yourself from the list also?
Yes.
Okay.
That's all you got, or you got another one for us?
We got a couple more here.
Okay.
They've been busy.
Okay.
And that last bill was introduced by the Speaker of the House, so that's got a decent chance of going somewhere. All right. I have hinted that they're broke down in Annapolis. They need our money, and they found a new way they're going to try and get it. House Bill 935, the Comprehensive Community Safety Funding Act. I love how they have these innocuous titles. An 11% excise tax on firearms, accessories, and ammunition sold here in Maryland.
Wow. 11%.
Yeah, wow.
almost double the regular sales tax, 2% more than alcohol.
And that would be in addition to the existing sales tax, or would that be, how would that, do you know?
This, it's still just been introduced, but it looks like this is going to be an excise tax charged to the dealer or the FFL
Who's going to pass?
specifically.
They're going to pass it along to the consumer.
Yes.
Yeah.
Yes. So, and it's going to be very interesting to see how this would actually work in place, what the comptroller's office would do. But Andre and I were talking before the show, if you ordered a firearm from out of state, had it shipped to your FFL, what is the excise tax that he's going to be assessed on that?
Right.
And then obviously on ammunition, which we all know is only still very high historically, it's not going to be easier to come down in Maryland with an 11% excise tax on top of it.
No, not at all.
Now, how this, like I said, is one of those great sounding laws, and it goes through where the money is to go. 44% of the money received is to go to the Maryland Trauma Physician Services Fund, 29% to the R. Adams Crowley Shock Trauma Center, 23% to the Violence Intervention and Prevention Program Fund, 2% to the Survivors of Homicide Victims Grant Program, 2% to the Center for Firearm Violence Prevention and Intervention within the Maryland Department of Health.
Does any of that go to Safe Streets or any of the gangs that run Safe Streets? Just curious.
If they applied for grants, they certainly could receive it.
So you're saying there's a chance?
Yes, yes. And that it's only fair that all of us should pay this excise tax to fund these noble organizations that are bringing order to city streets. This bill has a strong chance of moving forward. It's cross-filed with Senate Bill 784, and there are 30 co-sponsors in the House of Delegates.
Wow.
Regardless, I don't see what form that tax will take that could survive brewing.
You know, I wonder if they just don't care. I wonder if they're just going to throw every roadblock that they can and let the courts do what they do, and then they'll just do something else silly.
I don't disagree with you. I think that's the framework we're in now is legislatures, they're going to keep going, they're going to keep going, they're going to keep going until I think eventually maybe another decade or so, the Supreme Court will probably put itself back in a Second Amendment case, and you'll have another landmark decision because after Heller, the court did not step in. Well, Heller and McDonald, they came within a relatively short period, and the court did not really get involved dealing with Second Amendment cases. It allowed the circuit courts to set the law at the lower level until they got in with brewing. So right now, a lot of the cases, I think they're just going to allow the circuit courts to set the playing field until they find the right case to step back in and then say, hold up a minute.
And let's not forget the tremendous turnover in the composition of the court between those two dates, too.
Yes. Yes.
Well, and, you know, we talk about, and I'm sure we'll talk about it in a little bit once we get through this, is that the courts will rule, and I'll talk to people, and they'll be like, well, wait a minute, how can Maryland do this? This flies right in the face of a recent ruling or this and that. And people don't understand that the Supreme Court doesn't have a police department. They can't go to lawmaker X and say, well, Mr. Lawmaker, you keep proposing legislation that is that flies in the face of our recent ruling, or Governor so-and-so, you signed a bill into law. They just rule on cases.
Yeah. Put a different way, the court cannot preemptively say, okay, this is unlawful. The court has to wait for litigants to bring a matter before the court for them to opine on it.
Right. So, I mean, there's really a law gets struck down, a state pushes another law because they have an agenda. Maybe it's similar, or maybe it attacks what they deem as the problem in a similar way or slightly different way, and then it goes back up, and the courts have to rule on it again. That's just how it goes.
That's the nature of the game. It's like an arms race. The Second Amendment folks, you get a victory here. The state tomorrow will get a victory, and you keep going.
Well, people get very, you know, and I said it already, but people get very up in arms and they say, well, but how can the state or how can this entity do this when it's already been ruled on? And you have to explain, look, they have to take each case individually. They're not just going to say, oh, well, we can never pass another gun law ever. They're going to, if they have an agenda, they're going to go after it.
And they want to sap us of our time and treasure.
Yes.
They know they are well funded promoting these. The state is the defendant half the time. It's our own money being used against us.
Absolutely. They're using our own money against us. And so they have the deepest pockets of everyone.
And then the final one here, Duane, on the federal level, I'm sure some of our viewers are aware, there's the Protection of Lawful Commerce and Arms Act that was passed in 2005 that would protect a firearm manufacturer if from their product killing someone, assuming it wasn't a defective product or things of that nature. But similar to how you can't sue Ford for the drunk driver that hits you, you could not turn around and sue Colt for the firearm that shoots you. Well, here in Maryland, this was last year and we're at it again. We've got the Firearm Industry Members Gun Industry Accountability Act of 2024. This is House Bill 947. It's cross-filed in the Senate with Senate Bill 488. It's got a number of sponsors. And the goal, it would give any person or the Attorney General the right to sue a firearms manufacturer, seek injunctive relief, restitution, compensatory and punitive damages, reasonable attorney's fees and costs, and any other appropriate act. If they have, a belief that a firearm industry member has reasonable cause to believe a person intends to use a firearm-related product to commit a crime, or to cause harm to a person or another person, or to prevent the loss or theft of a firearm-related product from a firearm industry member, and to ensure that the firearm industry member complies with all provisions of state and federal law, does not otherwise promote the unlawful sale, manufacture, alteration, importation, marketing, possession, or use of firearm-related products, or engage in straw purchases.
So firearms industry member, this is going to be manufacturers. This could be dealers, people selling products, and it says firearms and firearms-related products.
A firearm industry member means a person engaged in the sale, manufacture, distribution, importation, or marketing of a firearm-related product.
Got it.
With that said, Andrew, let me bring you, I don't know if you remember, in recent years, is it Remington? Was sued, I want to say, on a Connecticut law.
Yes.
And even with the federal statute in place, they were successful. And they went after the firearms industry based on the way they marketed their product. And somewhere in that definition, I think I heard Andrew said marketing.
Yes. Well, they ended up settling for $73 million. They did not take it all the way to the hoop, take it as, clients walk in my office every day. I want to take it to the Supreme Court. They did not take it all the way. So they made a economic decision for whatever reason. Maybe they thought they were going to lose if they took it all the way. Maybe they thought the expense of taking it all the way was going to be greater than the settlement amount. So it was an economic settlement, but they settled for $73 million.
Even with the federal shield that existed.
Correct. They did not, as I said, they did not take it all the way. So this would bring this to the state of Maryland, and it's going to be a very broad number of people who are involved in here. And then also just pay attention. Some people will say, well, if I just don't sell guns, I'll avoid this. And firearm-related product means a firearm, ammunition, a component or part of a firearm, or a firearm accessory.
And you said the definition of a person is they have to be in it's part of a regular course of business or something like that? So my private sale from party A to party B, will that expose
Yeah, that's a good question, yeah.
This hasn't been tested. I don't see why it wouldn't. A person engaged in the sale, manufacture, distribution, importation, or marketing of a firearm-related product.
Yeah, it doesn't say a company. It says a person.
Yeah.
So, that leaves the door open for individuals, I would think.
Yeah.
So that's what you've got for Maryland.
Yes, so be be watchful of the legislature. They're out there in session right now, and they certainly can impact each and every one of our rights here in the state of Maryland.
And we do 3 updates on the Maryland legislative session. We've done one already. We're going to be doing our second one in March, which will be some point just after crossover. So stay tuned for that. We'll be going back over all of this again. It's where it's at, what its likelihood of passing is, and what its implications could be. So with all of that said, let's move on to the national cases, the national litigation. And we're kind of seeing some interesting stuff here, Andre. We're seeing a bit of a shift in the dynamic, aren't we?
Yes. Since Bruin, Second Amendment folks have been on the offensive. They're coming after a lot of what we probably have taught were like firm, rock solid foundational law on both state and federal side, and they're attacking them.
About damn time.
And so, but we're having successes here. We're having some actually very groundbreaking successes. Bruin being obviously a major one.
Yes, I would say it's more so a mixed bag. It all depends on which part of the country, which circuit you sit in. Well, for the viewers out there, the country is divided into 13 different circuits. And Maryland, for example, sits in the 4th Circuit. Maryland, Virginia, North Carolina, South Carolina, we sit in the 4th Circuit. And any cases that come up from the U.S. District Court, Federal District Court, that's the trial court level, the appeals court for us is the 4th Circuit. Any ruling that is made in the 4th Circuit, the states in the 4th Circuit have to abide by those rulings. Folks that sit in the 5th Circuit, such as Texas, they will not have to abide by a ruling from a court in the 4th Circuit unless the ruling at the district court level was a nationwide injunction of some kind. And then the circuit court upholds that nationwide injunction. Then everyone has to live under that nationwide injunction.
Reminds me of foreign shopping during 5 years ago when a certain president was in charge.
Are we not supposed to be doing that? I
And-
remember from law school, I was like, no, that's a no-no under the federal rules, foreign shopping.
And we're going and getting cases from Chicago to control immigration along the southern border and things of that nature.
So you have chosen for us a couple of cases that you wanted to talk about.
Yeah, and specifically, I picked out two blocks of cases, and or 2 particular areas. One is the minimum age. Everyone knows that to purchase a handgun anywhere in the United States, you need to be at least 21 years of age. That's on the 18 U.S.C. 1922. That's the federal statute. There are those cases, and then in the end, we'll speak about cases that came up after the Bruin decision on sensitive places where someone can carry a firearm with a permit. So let's go back to the minimum age requirement. First, we're going to speak about a case called Frazier versus the ATF. And this is challenging, as I said, 18 U.S.C. 1922, where it prohibits an FFL from selling a firearm, a handgun, to someone who's under the age of 21. There was a challenge to the case. This was a case out of the Eastern District of Virginia. The district court judge found that this restriction violated the Second Amendment. And let me just read what the initial argument was from the ATF. The ATF argued that the plaintiff lacked standing because they could still obtain a handgun from their parents through a private sale. What does that sound like to you?
Mm-hmm.
Sounds like a straw purchase by another name, encouraged by the government here.
Exactly. Because now the parents are purchasing a firearm, a handgun, for someone the parents know is a prohibited person.
Right.
So the court did not buy that argument. And then the court went on to say the challenge statute and regulation present more than a de minimis intrusion on the rights to keep and bear arms.
So just for the viewers, these folks went in to buy a firearm at a dealer, a handgun in this case. They were under the age of 21. They were denied, and therefore they filed an action. they weren't arrested, they weren't charged or anything like that. It was just that they were denied what they believed to be their right, and then they filed action.
Yes, they attempted to exercise their rights under the Second Amendment, and they were denied the purchase of the firearm, so their rights were constrained. So when our rights are constrained here in these United States, what do we do?
Take it all the way to the Supreme Court.
If you're in Maryland, you bend over and take it. But
Come on, man.
right.
We're not doing that a lot these days.
No, we're not.
So they did what any good American would do, and they bring a lawsuit. And they filed it down in the Eastern District of Virginia, and the court briefs were filed, arguments were made before a district court judge, and the district court judge agreed with the plaintiffs. So the judge also went on to say, ordinary common sense and logical meaning of the text of the Second Amendment include the rights to purchase arms. So if you have a right to keep and bear arms, it also includes you have to purchase it first. So an 18-year-old, someone 18 to 20, have a Second Amendment right.
I missed that part of the Second Amendment where it says it doesn't apply to persons above 18 but under 21.
So the court also went on to say many of the rights and responsibilities of citizenship fall on the shoulders of 18-year-olds. Note, then other amendments apply all Americans regardless of age, conclude that 18 to 20-year-olds are squarely within the ability of the Second Amendment to purchase firearms. So the judge, in turn, in that case, issued an injunction, enjoining the government from enforce a nationwide injunction.
Stop.
Yes. But the judge put the ruling on hold, pending an appeal.
An appeal to the Fourth Circuit,
Yes.
which for all those who were listening but not paying attention, would include the state of Maryland.
That's correct.
So what that means, though, is that although it was a nationwide injunction, it is stayed.
Yes. And let me
So you 18-year-olds don't get to immediately go out and try and buy handguns at the moment.
Well, if you're not in the Fourth Circuit, one of the states in the Fourth Circuit, you can attempt and try to vindicate your rights in your state if you're denied. Yet, but let's be clear. This is not a change in law. This is status quo as of now. Until the Fourth Circuit have arguments, brief, and issue a ruling, the law is you have to be 21 years of age in the Fourth Circuit to purchase a firearm, a handgun specifically.
Okay.
Because an 18-year-old can purchase a shotgun in the state of Maryland.
Right.
And just remember, fortunately or unfortunately, this young man's probably going to be 21 by the time they get a decision.
It's probably. And at that point, the government could argue the case is moot. But remember recalling back to my law school days, there was cases along the line with abortion, where it took more than 9 months for a case to get to the court, and I think the term they use is evading review or something like that.
I know what you're talking about. Let me get that term for you.
Yeah. So the case, while an 18-year-old, it can take at least 3 years for a case to work its way through the system to get a resolution.
So if the person that was aggrieved in this case is no longer aggrieved because of the fact that it's taken so long and now they're over that age, the case is gone?
It's moot.
It's okay.
Federal courts do not issue advisory opinion.
So could they, for lack of a better term, filibuster this thing with the intent to not have to rule on it?
Well, I don't think the court intentionally will just drag the feet out and not make a ruling on the case. Andrew, it seems like you have that term for me.
Yes, we are looking for the term capable of repetition, yet evading review.
Exactly. That's the term we're looking for. Capable of repetition, but
Sounds awfully lawyery to me, but
yes.
Okay.
That's the term because every 18-year-old could attempt to purchase a firearm and is denied. And the time that it takes for the case to make it through the legal system, they're now 21. Now that case is moot.
And with Bruin, everyone remember that was a 2018 case that was not finally decided until 2022.
Yeah. And the HQL case here in Maryland has been going since 2013.
Was it 13 or 16?
13, right
Okay.
after that law went into effect.
Okay.
And it's not concluded over a decade later. So these cases take time. So moving on, we have a similar case. It's with a different result. And this case is Reese versus the
Boo.
ATF.
Boo.
It's out of the Western District of Louisiana. And challenge to 18 USC 1922, but what the court found in this case is that they upheld it. They upheld the federal law.
And what circuit's that?
This is the Fifth Circuit.
So essentially, people went to buy a handgun. They were under the age of 21. They were denied. They filed action, and in that case, the court said, you're
Law is
nothing
good.
wrong was done. Yep.
This law, the 18 USC 1922, is not contrary to Bruin. So that's just to show you the flavor. Two different circuit, same issue, different result.
A dispute between the circuits, if you would.
And well, at the district level,
Right.
they're now headed up to both are headed up to the Circuit Court of Appeals. If both decisions are affirmed in the circuit court, it sets up more than likely that the Supreme Court will take up this case, because the court tends not to like to have two different rulings in a circuit on the same issue.
Until the Supreme Court takes it up, if they take it up, assuming all of this gets affirmed, you could be 18 and purchase a handgun in Virginia, but someone who's in Louisiana or anywhere else in the Fifth Circuit could not purchase a handgun until they're 21. That would be the outcome, correct?
That is correct. That is correct.
So I know we talked before the show about, how these cases come to be, these two specifically. And was it that these individuals didn't know what the law was, or was it that these individuals were intentionally attempting to be aggrieved and then have to be able to bring forward some sort of action?
This was probably, you would agree with me, Andre, I certainly support their cause, but done intentionally.
Yeah,
this was not a mistake.
You're trying to find
going
the perfect plaintiff to bring a cause of action. Yes.
So their actions were intended to cause the bringing of an action.
Yes.
Meaning that they didn't walk into a gun store and go, I didn't realize you had to be 21 to buy a handgun.
They're challenging the status quo. Yes, yes. And that's the only way the court will have the ability to rule on the constitutionality of this prohibition.
Sure.
Is that someone has to attempt to exercise their right, and that right is denied, and then bring a legal action before the court.
Got it.
The court doesn't sit there with the clerks. It's like, okay, let's go through the federal criminal code and see what statutes are unconstitutional, and then decree these statutes are unconstitutional.
Someone has to attempt to exercise a right and then be denied that right and then bring action.
Correct.
We need brave men and women to be test cases for the Second Amendment all across the nation.
Throughout the history of this nation, regardless if from Second Amendment rights to civil rights to same-sex rights to women's rights, someone had to be brave enough to step forward to be that named plaintiff.
Got it.
Ernesto Miranda was no accident.
No. There's a story about that. We could talk off air about it later. There was a final case that I brought on the minimum age requirement is Word versus Jacobson, and this is a case out of Minnesota. And
Minnesota, eh?
Yeah, eh? So there's a similar statute out in Minnesota which criminalize, if you're under 21, prohibits someone under 21 from purchasing a handgun. This was also challenged in district court in Minnesota, and the court struck it down. The government lost. So 3 jurisdictions, and Minnesota sits in the 8th Circuit.
The mighty 8th.
4th, 5th, and 8th. And 4th and 8th, you have an enjoining of the statute, but the 5th, it was upheld. Just to show you a sampling of what's going on around the country with these laws.
And so the interpretation of Bruin, and so for the listeners out there, why is the Bruin standard so different from what we had before? For those people that aren't familiar with what it actually does tell the courts.
Well, let's go briefly on to Heller. Heller allowed courts and policymakers. You look from a policy standpoint. Was this a good policy? Was it good for society, and so on? And then
Was there a rational
no,
basis?
I would like to say it was rational basis plus. It wasn't just plain all right, because the government almost never loses on a rational basis. It wasn't fully intermediate scrutiny but a lot of courts, even circuit courts, were analyzing cases under intermediary scrutiny. When it comes to fundamental rights, the court has set up a three-prong layer with scrutiny. Rational basis is the least restrictive. Strict scrutiny is the most restrictive. The government almost never wins when it comes to strict scrutiny. And then there's intermediate scrutiny. Under Heller was basically, I would say, argue rational basis plus. But a lot of courts, circuit courts, were analyzing cases under the Heller standard under intermediate scrutiny. Even right here in the Fourth Circuit in the Wooler decision, when that decision came down and I read it, I pulled my hair out, man.
And that's why you don't have any
that's
left.
gone. I mean, you
Yeah.
got all of it.
Yeah.
You must. He got mine too.
Yeah.
The court in Heller ruled that the right to bear arms is an individual right and it was a fundamental right. Prior to that, all fundamental rights decisions or analysis was done under strict scrutiny. The Woolard court analyzed that case under intermediary scrutiny, and that's how the plaintiffs lost in that case. So it was churning, these cases were churning, and then Bruin came along. I think the conservative majority on the court was just waiting for the right case to just dismantle this whole rational basis plus. And I think this history and tradition of firearms regulation of the nation, that's standard. There's not a lot of regulations in which will survive that test. Because at the founding, there weren't a lot of regulations imposed on the right to keep and bear arms.
So
there were some.
So the court has to. And by the way, the layout of the court currently is different now than it was under Heller as well. But the court has to look at these cases as what was in place at the time of the founding.
Yes, or something analogous to it. It does not, any regulation today, it does not have to be identical to a founding era regulation, but it could be analogous to it.
There were no the founding fathers had no regulations about the use of the internet and the trafficking of firearms.
Well, we don't regulate the internet on that standard. That's a conversation for another video.
Thomas Jefferson was blocked on Facebook back then for his pro-America beliefs. So, and in that same vein, I think you have one more case that kind of goes that direction, right?
Yes, and this case is the United States versus Ayala. I hope I pronounced Mr. Ayala's name correctly. And Mr. Ayala, I don't think he's still employed. He was employed by the United States Postal Service, and this is a case out of Florida. Mr. Ayala was permitted to carry a firearm in the state of Florida, and he did that. He drove one of those big rigs for the Postal Service, moving mail and cargo from one location to the next, and he carried his firearm in a fanny pack. I didn't know those were back.
Apparently they are.
Yeah.
I've been seeing more of them.
So one day he's coming into work and he noticed the postal inspectors are there for him, and he ran.
They wanted to see his sweet fanny pack.
Yeah, I
Probably
guess.
not the smartest thing to run, but I wonder how the fanny pack worked out with the running and the gun in there. That's why I don't wear fanny packs. They
yeah, the
look
decision.
silly, but
The brief did not mention anything about the fanny pack bopping
did it
around.
like come flying off?
Yeah.
And just run and go.
They didn't describe that.
Right.
So
Let's see if we can't find some pictures of Duane from the 80s with a fanny pack on.
So Mr. Ayala was indicted on carrying a possession of a firearm on a federal facility.
They feel strongly about that.
Yes, and resisting arrest. So the indictment went up, and a true bill was handed down. So we're going through the trial process, and it got before the
Andre,
judge.
I know what a true bill is.
Mhm.
But I bet a lot of our listeners don't. Does that just mean a bill that it's $100 and you've checked and you owe $100?
No, it's not. A true bill meaning is that the grand jury has returned charges against the alleged defendant at the time. And I always say an indictment is always it's handed up to the judge, not handed down. And that parlance the media tends to mix it up. An indictment was handed down. No, it's handed up to the judge. So the trial court judge in that case basically, using Bruin, went back to say, okay, in the history and tradition of firearms regulations in this nation, there was no blanket prohibition of possession firearms on federal property.
Mail carriers historically were often armed.
Okay, so the judge in the Ayala case, in her decision, she said, if a general societal problem has persisted since the founding, the lack of a distinct similar historical regulation addressing the problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. She also went on to say, if earlier generation addressed a societal problem, but it did so through materially different means, that too is relevant evidence that the modern regulation is unconstitutional.
So for the layman out there, what is your Reader's Digest breakdown of that?
She's basically saying if this crime existed at the founding.
No way.
The United States government had property at the founding.
No way.
But they wouldn't, through her research, there was no blanket prohibition of having a firearm on government property. So she ruled that law unconstitutional. So, to our viewers out there and anyone who's listening, that does not mean you're permitted to carry a firearm on federal property.
Getting ready to say, you better put that out there.
Or into the post office.
Yeah.
The government is appealing this decision.
And which circuit are we in down in Florida?
Florida sits in the 11th Circuit, but so this is at the trial court. I don't believe that they're going to be able to appeal this right now because this is still at a trial. This was not someone seeking injunctive relief. This is one of the counts struck from the indictment. The actual resisting arrest charge, he's going to go to trial on that.
Anything else that we want to add on that?
No, just stay tuned on this one. It's interesting how broad the court. I would like to see how broad the 11th Circuit will interpret that. Whether or not is it just the post office or what type of government facilities, federal facilities, can the government prohibit possession of firearms that are not in violation of Bruin?
Okay, so you have some more cases on sensitive places to discuss.
Yes, and these cases are more analogous to what we dealt with here in Maryland, which is currently on appeal to the 4th Circuit. So we're going to first start out in New Jersey.
They have their own version of the great and majestic Senate Bill 1?
They do. And I don't know who copied who. But as I was telling Duane before we started, it appears while I was doing some research on this, I realized that the states that are pushing these laws in these sensitive areas are the states that Bruin actually affected when it struck down their version of good and substantial cause. New York, New Jersey, Maryland, Hawaii, I think Connecticut, and one other jurisdiction that had this good and substantial requirement in order to have a wear and carry permit.
It was almost like a competition, like each state's trying to out-pull the other one.
Yes.
No constitutional carry in any of these states?
What do you think?
Right, right.
So
their constitutions goes first to Third Amendment, no second.
Skip it out. So like the Maryland law, I think New Jersey is similar where it prohibited someone with a permit to conduct, and you couldn't carry a handgun in a zoo. Ooh.
I mean, what if the animals attack you? I mean, you might need it.
The lions get frightened with firearms
Hey,
around.
look, I've been watching Tiger King again. Those things are dangerous, man.
Very.
You might need it.
Very.
Oh
You
my
are prohibited
God.
from carrying a firearm in a park, a beach, a recreation facility, or an area or a playground owned or controlled by the state, community, or local government, a unit, or any part of such place which is designed as a gun-free zone by the governing authority based on consideration of public safety.
Now I have a serious question. Duane, how would you carry at the beach? Would you wear a fanny pack there?
No, I just stick it right down my pants. You know the thing inside your swimsuit with that little
I didn't
netting?
I didn't know they made that for Speedos.
I just stick. No, man, I just stick it right in there. It's right in the banana hammock, man. That's where it's going. I mean, it's going to stick. It's going to. I mean, it's going to stick out a little bit because the thing's only like a G-string, but I mean, it'll hold it in place. It'll hold it in place.
All right, moving on. The law also prohibit carrying of handguns at youth sport events as defined by Jersey Code during immediately preceding and following the conduct of the event. So before, during, and after the event, you can't carry anywhere there's a youth event. Also prohibit firearms in publicly owned or leased libraries or museums. Sounds familiar to anyone?
Yeah.
Senate Bill 1.
Yep.
It also bars or restaurants where alcohol is served or any other site or facility where alcohol is sold for consumption on the premises.
Exactly from Senate Bill 1.
Prohibiting firearms in privately or publicly owned and operated entertainment facilities within the state, included but not limited to the theater, stadium, museums, arenas, racetrack, or other places where performance, concert, exhibit, games, or contests are held. Sound familiar?
Yeah.
Yeah.
Contests.
Prohibit handguns at casinos and related facilities, included but not limited to hotels, retail premises, restaurants, and bars on the facilities.
I wonder who wrote all this.
But here's the catch. This section of subsection 18 of that New Jersey Code, it excludes bars, but subsection 15 includes bars and restaurants.
Anywhere
That was nice of them.
alcohol served
Yeah.
for on-premises consumption.
It also airports and public transportation hubs.
So here's the problem with the airports bit, and that question gets asked to me a lot, is you're allowed to travel with a firearm.
We'll get there.
Okay.
When we go
All right,
back, we'll go through each
There's
one.
more?
Okay.
There's more. We'll go
All
through
right.
each one of the section of the code, and then we'll speak about how the court ruled, because some of them were enjoined in part, some in full, and some were just terminated pending a full evidentiary hearing.
Okay.
So, prohibiting handguns in healthcare facilities, including but not limited to general hospitals, special hospital, mental psychiatric hospitals, public health center, diagnosis center, treatment center, rehab centers, extended care facilities, skilled nursing home, etc. Prohibit handguns in facility licensed or regulated by the Department of Human Services for children and families or the Department of Health, whatever those facilities are in New Jersey. And prohibit handguns at public location being used for making motion pictures.
Definitely want to stop that.
Not something we have here in Maryland.
House of Cards was here.
Yes, it was. Okay, private property without the express consent of the owner or the owner's agent. Sound familiar?
Right.
Did they just copy us?
I
somebody's
think
writing
we copied them because New Jersey went first.
where there's coordination. I
Yeah.
mean, there's
Yeah.
probably clear coordination.
This is the
here.
one.
Plagiarism.
This
You know
is
the
the one-
Democrats like to
Yes.
plagiarize.
Come on, man.
This is the one that got me. The law also prohibit a licensed firearm holder from carrying a functional handgun in his or her vehicle while transport.
functional.
It has to be inoperable.
And do they define how it has to be made inoperable? Does it have to be disassembled, or does it have to be like locked with a locking system?
Are we bending the firing pins?
It cannot be separated apart, basically dismantled.
Wow. So they don't have to install one of those barrels that comes out the end and then points back at you. That's the only Democrat-approved handgun on earth. Yeah.
So
Elmer
Let's go.
Fudd.
let's go through the sections of the law, what happened Cases were briefed in the district court, and it was a lengthy opinion. Reading this opinion, I felt like I was back in law school. It was almost 300 pages.
Oh my God.
Wowzers.
Yeah. So, on the first part, in the zoo, prohibiting handguns in the zoo. The court terminated this section of the code. They didn't rule on it until they have a full evidentiary hearing. The court, they didn't have enough information.
I want to know about the historical precedents of regulating the possession of firearms in zoos. I'm certain that the founding fathers were very concerned about that, and they did not want, the right to keep bear arms. They did not want bears to
I
not
was
have
going to say
arms.
there's bears in the
Yes,
zoo. I mean,
yeah.
So,
if Joe Exotic would have been elected president back in his presidential run, he would have fixed all
Care
these
basket.
problems
Yes.
with the
That
zoos
was-
specifically.
that was something similar to what the court basically said. They wanted an historic brief specifically on the zoo. They also terminated the issue with the airport because under federal law, you're allowed to travel with a firearm if it's properly stored in check bags. And the court went into this long analysis of with the way the airports at Newark are situated. You get in and you're at the TSA. There's not a lot of room for you to be hanging out and all that type of stuff. I don't know how. I can't imagine how that is, so the court dismissed that part of it until they have a full evidentiary hearing. But in the ruling, the court said until a full evidentiary hearing, you are permitted to fly with your firearms as long as you comply with federal regulations. So if you're packed in your bag and you're going to check it that way, you can come into the airport.
And you declare it with the airline, and
Yeah,
TSA has to handle it. Follow all their guidelines.
The court did carve that out until they're able to fully rule on whether or not to enjoin that section of the code.
Going as to what we touched on earlier, the time and treasure that will be spent arguing this, you're going to have to find the preeminent expert on zoo laws from way back when.
Yeah, like at the time of the founding. Were
Yeah.
there zoos? I mean, maybe private zoos.
I don't even know. And then what were the laws that applied to them? If you're a zoo law firearm expert, you're about to have your 5 minutes of fame. Enjoy it while it lasts.
So, on subchapter 10 of the statute, where parks, beaches, recreation facilities, or areas or playgrounds owned and controlled by the state and state or county and local government units, the court enjoined application of the law in parks, beaches, recreation facility, and state or county owned local government units, but they allowed it to stand on playgrounds.
So this summer, Duane and I will be at the beach. I'll be with my fanny pack. Duane will be there with his G-string, and he can be packing.
That's a new season of the Jersey Shore, man.
Beat the beat.
So that was enjoined in part and permitted to stand in the other part. Now let's move on to publicly owned libraries and museums. That was enjoined in full.
Mm.
The court says there's no historical statute analogous to this because a lot of libraries, museums, they were really not a thing at the time of the founding.
Once again, if you're the firearm law librarian, this is your moment.
Yeah.
Enjoy it.
Yeah. And bars, restaurants where alcohol is served, enjoined in full. So while the state celebrated this, and I couldn't know, when I looked at the press releases, the state basically celebrated that they had a partial victory and they're going to keep fighting. But reading the decision, I couldn't see, I guess the partial victory here is the playground. It's not being able to enforce on. And the other two sections that were terminated pending a full evidentiary hearing on them. But for the most part, it's for Second Amendment folks in New Jersey. I think this ruling from the district court was a win. And just for some background here, this case was argued, I think, a week ago.
Okay.
And before the circuit court. So we should expect a decision in the coming months from the circuit court.
Still not enough to get me to move to New Jersey.
I'm with you.
Yeah.
Now let's move to privately and publicly owned entertainment facilities. That was enjoined in full. Start to see a theme here.
Yeah.
Now move on to casinos, enjoined in full, prohibited, we mentioned that. Healthcare facilities, including but not limited to general hospital, enjoined in full.
Yeah, I would say there was doctors back then, and all of places where doctors performed their medical services.
But let's move on to the biggie.
Okay.
Privately owned property without express permission of the owner or agent, enjoined. Enjoined in full. The court basically said the owner has the right already to ask you to leave your property.
Right.
Where in the history of firearms regulation this type of show me something analogous to this? And the state in their brief could not come up with any analogous statute. As I said, Bruin does not require you to have an identical statute or an identical regulation, but let's say for the regular folks, let's use lawyer word. Give me something that is similar enough that I can hang my hat on and say, okay, there you go, state. You have showed me something from the history that is similar to this.
So New Jersey is celebrating this as a win?
At least in the press release.
They're probably still getting schools, hospitals. Yeah, so they're getting some areas.
I mean, I guess from an incrementalism approach, their idea could be over the next decades, they're just going to keep trying to pass stuff and see what sticks. But
time and treasure, baby.
Yeah.
Also, the requirement that you have your firearm when you're in a vehicle inoperable, enjoined in full.
Of course.
The state the courts couldn't find anything. They definitely couldn't find anything analogous to this. What are you going to analogize this to?
On my horse.
Or in your buggy?
Yeah.
Yeah.
Come on.
Yeah. So
moving on, we have Jersey, Hawaii. They have a bunch of regulations that are similar to New Jersey and similar to SB 1. So I'm not going to bore you to death and go through all the different sections of it. But what I found that stood out in the Hawaii statute is that they even included the parking lots or the parking area that is a prohibited place now or a sensitive place.
So, oh crap, I'm going to a sensitive place. I'm going to have to turn around and go home. I can't even leave my gun in my car.
Unless you park on the public streets.
So they took it a step further. They out-assholed the assholes.
Yes,
Okay.
yes. So one section of their statute, any building or office owned, leased, or used by the state or the county and adjacent grounds and parking areas, including any portion of the building or office used for court proceeding, legislative business. You get the gist of that. The court enjoined the parking areas section of the statute. They left the government buildings in place. And that was even permitted. Even Bruin permitted the government to bar the possession of firearms in the government building itself to an extent.
Okay.
And what circuit's Hawaii in?
Ninth Circuit. So next section of the statute, the bars and restaurant, that was enjoined just like here in Maryland, New Jersey, Hawaii. And as I said, these are three of the states that Bruin actually affected. And it just seemed they all came with the same thing, bang out the door. New York is a bit more complicated. That's why I didn't include the New York litigation in these cases. That might be a video onto itself, just New York, because there's just so many moving parts in New York. And where did the Bruin case started?
Right in New York.
Okay, then. So Hawaii takes a different approach, a somewhat slightly different approach from New Jersey. Any beach, playground, park, or the adjacent parking lot is, again, the parking lot, it's a difference. You can still, it's enjoined in the beaches and parks and adjacent parking lot. You still can't go to a playground. Basically, how do you define a playground, I guess?
Yeah, I mean, I'm not sure what the legal definition of a playground would be. It's like one of those things, you know it when you see it, I guess.
Just like pornography.
I was just about to say that, man.
Just like Duane in his Speedo.
How is it like pornography? You know it when you see it? It's like...
That's what the late, great Justin Antonin Scalia ruled in a First Amendment case. Like, what is obscenity? You just know it when you see it.
Okay.
There's actually no real definition. That's in a Supreme Court case. You just know it when you see it.
Back to
It's
Duane.
like when you open that thing up and you go, oh, yeah, that's a penis. that's pornography.
Yeah.
Yeah.
Duane in a Speedo with his gun in it. That's obscene.
It might be. It's hard to say. Hard to say.
So correct me if I'm wrong here, guys.
Ladies do like it, though. I mean, I don't know what to tell you.
It's 2023, Duane.
It
No,
is.
strike that. 2024.
There you
Men
go.
like it too.
Well, they may, but they can keep it over there.
So tell me this. Did SB 1 prohibit the wear and carry of a firearm in a bank or a financial institution, including the adjacent parking area?
No, not that I'm aware of.
Not explicitly, just through its backdoor prohibition of anywhere that didn't say bring one in.
Right.
So Hawaii went even further than New Jersey. They included banks, financial institutions, and the court's like, no. They enjoined it completely.
Certainly those institutions existed at the time of the founding.
There certainly were banks. There might have been some controversy over banks throughout the early years of the nation's history.
They were, but there weren't any blanket prohibitions on the right to possess firearms in a bank or a financial institution at the founding.
The firearm banking expert. Enjoy your time, baby. You're going to Hawaii.
And they also had the biggie, carrying a firearm on private property without the express consent of the owner, which was enjoined in full. So there's a theme here with these cases where the states are just trying every way, shape, or form to prevent you from carrying. And in the New Jersey decision, the court basically said, in just an opining in dicta, is that you gain the right under Bruin to carry, but the state of New Jersey has gone out of their way to make sure there's really no area in the state in which you can carry.
I was going to say this is their response to Bruin.
Yes, this just the way SB 1 was a response to Bruin. These two statutes in Hawaii and New Jersey are a response to Bruin. The New York statute was a response to Bruin, and I think Connecticut passed a statute in response to Bruin. It's just the Bruin response.
What is your thoughts on where it goes from here with what we're seeing?
Well, with all of these cases, the next step is the circuit court level. Some of them have been already briefed. Some have been heard. Oral arguments have been heard. So within the next 6 to 8 months, we should hear something from, if not all, most of these circuits, and then see where the playing field goes from there.
So basically, stay tuned.
Stay tuned.
Because there's going to be a lot more to come.
This year is going to be a fun year for the Second Amendment with regards to litigation nationwide. A lot of decisions are going to come out of these cases. And let me just say, outside of what Andrew and I were opining on earlier with the minimum age requirement with a different decision in the Fourth Circuit versus the Fifth Circuit, is likely a lot of these cases the Supreme Court may reject them, because the cases that I did not include here that I researched that were challenged on the Bruin were basically assault weapons ban, magazine, high capacity mags. A lot of those cases, the circuit had ruled in favor of the government, and the plaintiffs appealed the cases to the Supreme Court, and the court rejected all of them. The court has not. There's one case I think the court's currently taking up this term. It's on a Second Amendment issue. I think it's a domestic violence, someone who's on a domestic violence order being in possession of a firearm.
Big misunderstanding affected that young man.
So that is the one case, and that's a big case because that goes will go right up against, I think that's the Lautenberg Amendment.
Every time when we're just discussing picking your plaintiff, he would never be the plaintiff I would pick in a million years.
Hey, you take the ones you have, man.
As we said, you wouldn't pick Ernesto Miranda either.
No.
But yeah, no. And Ernesto Miranda, for all those watching and listening, the source of Miranda rights.
Yeah, the Miranda warning.
Yes.
Miranda via Arizona.
Stabbed to death in a bar later on, I believe.
Mm-hmm.
Didn't know that.
After he was convicted on something else.
Yes.
And this time he was actually This time it was actually read his Miranda rights.
So he was read his own rights.
Yes, and
The-
he was
the-
convicted, and I think he got stabbed after release or something like that.
So this gentleman was a true American hero, an American patriot. He was
Yes.
a pillar of society.
Yes,
Okay.
yes, an upstanding member of the community.
Yeah.
All the landmark cases that you hear a lot of them are just ordinary Americans, man. It's usually that's the way it starts because you have to find as Andrew referred, you have to find the right plaintiff.
Right.
So a few years back, it's almost a decade ago, PBS had a series they call Landmark Cases. And they just went over a bunch of these big landmark cases. A lot of them came out of the 60s, like Gideon versus Wainwright in those cases, dealing with some rare core constitutional issues. And prior to Heller, there was, there was one really big Second Amendment case, I think back from the 30s.
Dealing with machine guns.
Dealing with machine
yes.
guns.
Was it the
But-
Gun Control Act of 1934,
Yes.
Yes.
Yeah.
But a case never really went anywhere.
which
because,
established the NFA, I believe?
It did.
Yeah, because one of the litigant, not the government side, the plaintiff, or I couldn't remember which side he was on. He was not represented by counsel, and I think the government didn't even bother to show up for the arguments or something like that. But that was like really the first big case, but it never really went anywhere.
That's why you need to get lawyers that know what they're doing. And speaking of which, what did Gideon provide everyone?
The right to an attorney.
You've got it. The Office of the Public Defender.
Yeah,
There you go.
yeah, doing God's work.
The Constitution is not a technicality.
Okay, guys, any final thoughts?
Well, Duane, I'll keep my eye out. I'll be on the lookout to see what's coming down the pike next, and just keep an eye on these litigations. And I'll come back and we'll discuss.
Andrew.
I'll be keeping my eye on Annapolis, and after crossover day, we'll be back with a much better idea of how they're going to infringe on the Second Amendment this year.
Fantastic, then. Well, then for the Urban Defense Podcast, I'm Duane Urban, along with Andrew Saller and Andre McDonald. Remember to share, like, comment, and subscribe, and train, fight, and win.